Okay, I am heading to the Secretary of State today, the Driver Assessment Appeal Division, to challenge an implied consent refusal. So this is the type of case where someone has been alleged to have been driving drunk. The officer stopped them, arrested them, and then demanded that they take a chemical test. So what is an implied consent hearing? Well, the state of Michigan, the law, says that if you operate a motor vehicle on a public road, then you have already consented to take a chemical test if you are arrested for drinking and driving. Implied consent only kicks in if you've been arrested. The PBT on the side of the road is used in order to get enough evidence to arrest you. If you refuse the PBT on the side of the road, it's a civil infraction punishable by $200, and it doesn't show up on your driving record. If you've been arrested, though, for drinking and driving, then implied consent kicks in. And if you refuse the implied consent test, then you lose your license for a year. You also get 6 points on your record if it is alleged that you refuse the implied consent test. Then you'll be given, or should be given, a piece of paper that says that you refused, and that if you don't do anything about it, your license will be suspended for a year within 14 days of the refusal. You'll get a notice in the mail, and it'll look something like this. And it actually tells you the legal ways that you can appeal an implied consent refusal. The first one is whether the peace officer had reasonable grounds to believe the petitioner, you, had committed a crime as described in section 625C. Did the officer have reason to believe that you committed the offense of drunk driving? The second way that you can appeal an implied consent refusal is whether you were arrested for a drinking and driving offense. A scenario like that might be if you were arrested for driving on a suspended license, and then maybe the officer later somehow determines that you've been drinking and is now demanding that you take a chemical test. That situation doesn't happen very often. The third way that you can refuse an implied consent test is that the officer is required to advise you of your rights. Now, they're not going to give you legal advice. They're just going to read from a piece of paper that will essentially say what happens if you refuse the test. That's all they have to do. But if they don't advise you of your rights, then you cannot be found responsible for violating the implied consent law. Finally, the fourth way that you can appeal an implied consent refusal is whether the petitioner, you, unreasonably refused to submit to the test upon request of the peace officer. Stated another way, was your refusal reasonable? One way that someone's refusal could be considered reasonable is diabetics are excluded from this law. I suppose another way that it could be found that you did not refuse improperly would be if you were unconscious. Then that would make sense as well. Consent hearings are not easy to win, and anyone that tells you that they're easy to win is lying to you. Every case is different. You may have a good case, and your case may be easier to win than others. But even though they are difficult cases to win, I always recommend that someone requests the implied consent hearing when it's been alleged that they refused for a multitude of reasons. First off, if you make the request, then your license will not be suspended in 14 days. You will have at least up until the hearing to continue driving, which is good for you. The other reason, in even the most difficult case, is that the burden is on the police officer. So if the police officer doesn't show up, you win by default. It doesn't go on your record, and you keep your license. The third reason I would recommend that you should always request an implied consent hearing is that you have the right to appeal it. You can have a hardship appeal. A hardship appeal allows you to go to the circuit court. Your burden on a hardship appeal is simply to show that if you're not given a license, you'll suffer a hardship, which is generally a pretty easy burden to reach. To date, I've never had a client been denied a hardship license. A hardship license allows you to drive to work, to school, to necessary medical appointments, as well as court and court-related issues. If you requested the hearing, again, it gives you more time before your license is suspended. And when you go to the hearing, it isn't uncommon for the hearing officer to give you a month or more to get your affairs together. In that time, your attorney can get the papers ready so that you can have your petition to the circuit court. That way, the lapse of you having a license either is non-existent or minimal. So, if you're about to lose your license because it's been alleged that you refused the implied consent test, give my office a call, 734-453-7806. I do a lot of these cases, and I take a lot of pride in my work. I hope that this video was helpful. If you have any questions, feel free to give me